Maryland, like some other states, have laws known as assault weapons ban. First, we have to define what Maryland calls an assault weapon. The statute defines assault weapon as an assault long gun, an assault pistol, or a copycat weapon. The term assault long gun, in turn, encompasses more than 45 enumerated long guns or their copies, regardless of which company produced and manufactured the firearm. These proscribed guns include an assortment of military-style rifles and shotguns capable of semi-automatic fire, such as the AK-47, almost all models of the AR-15, the SPAS-12, and the Barrett 50 caliber sniper rifle. The term assault pistol encompasses more than 15 enumerated firearms and their copies. These include the Tech-9 and semi-automatic variants of the MAC-10, MP5K, Uzi, and other military-style submachine guns. Maryland defines many different rifles, shotguns, and pistols as assault weapons. Now, many of these weapons are actually semi-automatic weapons as opposed to the full automatic many people think of as assault or military-style weapons. Maryland also defines a copycat weapon. Copycat weapon is defined as a firearm that is not an assault long gun or assault pistol, yet is covered by at least one of the following 6 categories. A semi-automatic centerfire rifle that can accept a detachable magazine and has any 2 of the following: a folding stock, a grenade launcher or flare launcher, or a flash suppressor. A semi-automatic centerfire rifle that has a fixed magazine with a capacity to accept more than 10 rounds. A semi-automatic centerfire rifle that has an overall length of less than 29 inches, a semi-automatic pistol with a fixed magazine that can accept more than 10 rounds, a semi-automatic shotgun that has a folding stock, or a shotgun with a revolving cylinder. What I find interesting are the banned features that have nothing to do with the lethality of the weapon. For example, how does a folding stock or a flash suppressor make the weapon more lethal? The answer is it doesn't. Maryland law prohibits any person in the state from selling, purchasing, receiving, transporting, transferring, or possessing an assault weapon, subject to limited exceptions. That's from the Maryland Criminal Code. A violator of these statutes faces up to 3 years imprisonment. Maryland law enforcement officers are authorized to seize and dispose of weapons sold, purchased, received, transported, transferred, or possessed in violation of the law. There are several constitutional issues with this Maryland law, not just the Second Amendment. Chief among them is the confiscation of so-called assault weapons. For example, is it reasonable for law enforcement to seize property that was legally purchased? It's one thing to seize an item that was purchased or even transported in violation of the law, but what about the weapons that were purchased, received, or transported before this law went into effect? This law potentially violates the Fourth Amendment, which reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." It also violates the 14th Amendment, which states, "Nor shall any state deprive any person of life, liberty, or property without due process of law." Now, those who challenge the law did not claim it was a violation of the 4th or 14th Amendments, but of the 2nd. Appellants are 3 Maryland residents who allege that they are legally eligible to possess and acquire firearms, 3 nonprofit gun rights organizations to which the residents belong, and a licensed firearm dealer based in Maryland. On November 13, 2020, appellants filed a complaint under 42 U.S.C. Section 1983 in the U.S. District Court for the District of Maryland against the then Attorney General of Maryland and other state law enforcement officials. Appellants contend that these officials' enforcement of Maryland's assault weapons regulation was unconstitutional under the Second Amendment's right to keep and bear arms as applied to the states through the 14th Amendment. They sought a declaratory judgment that the regulation prevented them from exercising their right to keep and bear arms, as well as an injunction to prohibit appellees from enforcing the statute. Again, we have the lie that the Bill of Rights did not apply to the states until the 14th Amendment, which is all based on a claim written by Chief Justice Marshall without any evidence at all. I go into more detail in the article of the Bill of Rights and the States, which you can find on the website. The question remains, though, does this Maryland law violate the Second Amendment? In their complaint, however, appellants acknowledge that the result they seek is contrary to Colby v. Hogan. In Colby, we upheld against a constitutional challenge the very same Maryland statute at issue here insofar as it applied to the assault long guns and those copycat weapons that are rifles and shotguns. Our en banc opinion rested on 2 distinct grounds. We first concluded that the assault weapons at issue were not constitutionally protected arms. We then found that, even assuming the Second Amendment reached such weapons, the Maryland regulations survived intermediate scrutiny. Bianchi and company agreed that what they were asking the court to do was contrary to their previous opinion in Colby v. Hogan. Now, between the court's decision in Colby and this case, however, the Supreme Court had decided the New York State Rifle and Pistol Association v. Bruen. On June 23, 2022, before ruling on the cert petition, the Supreme Court decided New York State Rifle and Pistol Association v. Bruen. In Bruen, the court disavowed as one step too many the two-step framework that our court used in Colby and that other federal circuit courts had nearly universally employed to assess Second Amendment claims in the wake of District of Columbia v. Heller. Although step one of the predominant framework, which was rooted in the Second Amendment's text as informed by history, was broadly consistent with Heller, the court emphasized that the means-end scrutiny at the second step was improper because the Second Amendment codified a pre-existing right. Courts were not to engage in interest balancing to determine whether a challenge regulation was constitutionally permissible. Instead, we were tasked with discerning the historical scope of the right and parsing whether the challenge regulation was consistent with it. The Supreme Court said the Fourth Circuit got it wrong in how they analyzed the case. Now the court had to look at whether the law fits within the constitutional text and history. A week after Bruen was decided, the Supreme Court granted appellant's petition for writ of certiorari, vacated the judgment, and remanded the case for further consideration in light of Bruen. We ordered the parties to provide supplemental briefing, and a panel of this court heard oral arguments on December 6, 2022. Before an opinion issued, however, our court voted to rehear the case en banc. We received additional supplemental briefings from the parties and heard oral arguments as a full court on March 20, 2024. Now, with the benefit of Bruen, we can proceed to decide this case. The court GVR'd, or granted certiorari, vacated the judgment and remanded it, or granted, vacated, and remanded, and sent the case back to the Fourth Circuit to consider it based on the Supreme Court's opinion. This is where some shenanigans came in.